Good morning, judges. My name is Robert Lee Bean. The issue at hand involves a residential lease agreement, and the appeal is about the motion to determine rent and subsequent order of possession. My issues here today are jurisdiction and errors created by the lower court and jurisdiction. The appellee was barred from filing the eviction action altogether for possession under collateral estoppel. The landlord, Mr. Footman, the appellee, was an agent for our grandmother, May Flowers, the principal, who is now deceased. When this action was filed in March of 2022, March of 2022, there was already a pending unlawful detainer action filed by the principal and successor agent that was filed in December of 2021. So by that still pending, that case didn't conclude until September of 2022. But the appellee went ahead and filed for an eviction, although the unlawful detainer case was still pending and the parties were still actively litigating the outcome of that case. Also, the amount of controversy exceeded the lower court's jurisdictional limits because in the eviction complaint, the appellee included 4 of the 7 pages of the lease, whereas 5 through 7 included a lease option that had already been exercised and consideration had been paid. So it was a contract pending completion. With that being said, the amount of the sale and the amount of controversy due to the terms of both the lease itself, the conditional terms of the lease itself, and then also the option exceeds the lower court's $30,000 jurisdictional limit. The next thing is the lower court relinquished jurisdiction when ordering parties to mediation. There was a motion to dismiss hearing, and then 10 days later, there was a motion to determine rent hearing. Between that time, the court ordered the parties to mediation, but I didn't receive a copy at all. I didn't even see it in the docket prior to us attending the motion to determine rent. By me not receiving that and the court not bringing it to our attention while we were at that hearing, it deprived me of due process. And also because once mediation started, it's my understanding the court has stayed from further proceedings until mediation has concluded, and mediation hadn't concluded at that point in time, and it was court ordered, I guess on the court's own motion. The errors that I have, the eviction complaint was filed in March of 2021, but we did not make it to court until October of 2021. So I had timely filed a motion to determine rent with my answer on or about March 15th, and I followed up with the court repeatedly, and the court basically just said, just wait for the judge. There wasn't a delay in the docket. We didn't go into court until September when I filed a motion to dismiss, and I think at the same time, a day or so later, the appellee filed a motion for default. And that's what brought us into court initially. The court had not moved on the motion to determine rent, and it didn't seem that they were going to make a move until we filed those 2 motions. So those delays created forgive me for a second. Those delays thwarted the legislative intent of me having to pay rent in order to continue defending the action, because there was a 7.5-month delay of the court taking no action to hear the motion to determine rent. The next error was the failure to review case files to ensure standing in jurisdiction and also to properly determine the amount of rent owed. In the lease itself, the appellee was supposed to receive a certain amount of money, and there was a certain amount of money that was supposed to be paid directly to the principal for specific reasons. The court didn't review those files. They didn't listen to my objections. But that in itself, by not adhering to the lease itself, the contract that brought us into court, the court erred, and that led to their erroneous amount of rent due in their order. So basically, when they inaccurately determined the rent, they didn't provide any kind of information on how they came about that amount, nor did he state it in court. It's inconsistent with the appellee's ledger. It's inconsistent with my testimony. It's inconsistent with the lease. So I don't know where the amount was derived from, but it was erroneous altogether. I'll reserve 5 minutes for any rebuttals, but that's all I have.
Okay, thank you, sir. So you'll have the 5 minutes when you come back. Yes, sir.
Morning, Judge. My name is Julius Flipper. I'm the appellee, however you say it. But as far as this case about the lease, I have the paperwork, everything matched up, as far as what he owed for the rent. He had numerous amount of months to even say, hey, here you go, Julius. Nothing was given in the rent. He made a bunch of frivolous accusations to lead me and him to even get to this point. I have the whole agreement. Everything was furnished correctly in the courts, all the necessary paperwork. What me and the judge went over, or what the judge went over with me and him, and he read it thoroughly and carefully. It's all in documented, and I have it all. And I feel that the lower courts did a perfect and adequate job by going through and seeing he had ample amount of time. Like I stated, the time was given. And for one of the things he said in the court, he felt that he didn't have to pay rent at all. And that's kind of, not understanding on what he said was in the lease. And that's pretty much it.
Thank you, sir. Sir, you have up to 5 minutes.
I don't really have much to add to that. There was nothing new that he stated that was outside of his brief. I did forget to include one of the errors that the court made. If I am able to do so.
Sorry, what do you want to do?
There was one other issue and matter I wanted to raise and argue here that I did get a chance to.
Okay.
Am I able to do that?
I mean, ordinarily, your argument is to address what he said, but I'm going to go ahead and allow it. I'm not hear what you have to say.
Well, like I stated earlier, our grandmother, the principal in the power of attorney, had already passed. She had a will that was deposited with the court. The will listed beneficiaries, and under both the rent that was supposed to be paid directly to her and the amount of the sale of the house that was supposed to be divided between the beneficiaries, when the court allowed him to come in and represent the matter or argue the matter without notifying those beneficiaries because she had passed, they allowed Mr. Footman to allow him to basically partake in the unlicensed practice of law, because he then represented the interests of the beneficiaries listed in the will at that time during each hearing, because she had already passed. That's all.
Thank you, sir. Thank you both. Well, we're done. We've got to stay by the rules, okay? And we're all through, and I appreciate what y'all did, okay?
Thank you.
Thank you. Our next case will be Sarasota Doctors Hospital and Englewood Community Hospital versus Sarasota County.